okayfm 101.7.
Na be na do redu mi mo ache.
You are calling me Joseph.
Na boko de.
Oh, Yaminti, me ho ye. Na me say also on to say.
Me so me ho ye pa.
Me so me de kwame yo.
Hey!
Me de kwame read.
Oh yeah.
Me dia no pa, me dia penny. Ana me wa fampo no.
There be me sa me nya 44. Wadaruma chama Wontumi issue yi abayi yemfa nko yemfa mra ya bearing ba be conditions no he's not been able to meet yemfa nko yemfa mra no me de keka ho nyina yesi binum kwa de japade aba wo me de beba no wo behwe na indenture any land title yemfa go bi kwa senka yema no property bond eno so wo mantimi anye sa na weni nyina ujini say
You are medical chair with people. And some labano, I have to say, bill bond ni a home community. There's a very fundamental issue as a lawyer for any ubia oka the Wontumi as a on train agents. Now, for me, the constitutionality or otherwise, or the legality of otherwise, EOCO for a keeping should be what we should be discussing. And I believe that EOCO, they are coming a bad precedent. Shani Yanka, no man, and they won't to me, fortunately, and I will be for an ample. We are coming. Anything, okay, in Constitution, Article 14.3, Mira, there will be now Obama with for a Hunchishima.
Article 14.3.
14.3, but just obey me.
Maybe the kindness is here. Okay. Article 14.3. But the watch over in or say 14.3.
But A and B, the no baby or last paragraph.
Okay, or say a person who is arrested, restricted, and detained. A. For the purpose of bringing him before a court in execution of an order of a court. Or B. Upon reasonable suspicion of his having committed or being about to commit a criminal offense under the laws of Ghana, and who is not released, shall.
Who is not released, shall. But your
who is not released, shall be brought before a court within 48 hours after the arrest, restriction, or detention.
That's it. Era near EOCO for a year. A bit me out to be a bit me out. Mammy Mountain Muka. Ghana Constitution, they say, the what should be the way deep on it. Now, Shannon say, 48 hours. Now, person will only be within that 48 hours. Who bet me keep the person in your custody. Now, why? Now, 48 hours, next 20 years, when you won't find say, who be keeping the panipium. And so the local court, now court to say, for now, you look home, for Nami and Sakahon, and for Nami look home. Near EOCO, yen say, or should I keep you not 48 hours now? No amount bill conditioner, Unconstitutional for failure. Ain't for 48 hours, near Suria, no, there were cast and you know 48 hours, no, there were amount bill when I went to MBT bill conditions. And so, kind Article 14.3 now, yes, nobody can be kept in the custody of any investigative body, police or EOCO more than 48 hours.
Whereby more bail, but you've not been able to meet the bail conditions.
I want to make us say bit me up and a highly unconstitutional. And you almost 48 hours. We are coming with the Mr. Namid Way and Fatima. Yeah, the work off. Yeah, dilly dally and if I or 48 hours listen. 48 hours missing and near more bill, 100 million cities. Went to near meeting. Are you still not in the custody of EOCO?
You are still in the custody of EOCO.
Is it no more than 48 hours? So they are using they are using that strategy to frustrate people and to breach the Constitution, because Constitution is a 48 hours. It's absolute. Supreme Court has said even Saturday and Sunday crack out. Internet first show be Friday. Yes, I guess a Monday. Supreme Court said there be 48 hours. Absolute. Engineer EOCO and it's only be a Dubois, only be so you won't see. And then I'm a first time lawyer for June Johnson and say EOCO is setting a dangerous and a bad precedent ni omeya ni se ombechi wakotun for 48 hours ni so ani ama 2 billion bail yes Wontumi see them but what they are doing is very unconstitutional and they want to meet ABI but but what EOCO is doing is an affront to the constitutional provision. Particular reference to Article 14.3.
Sir, we counsel for Chairman Wontumi. Gain anka obeye.
First and foremost, remember EOCO for the 48 you're coming. Who really 14.3 no official is imperative.
Imperative,
yeah. Constitution is based to shano. Imperative. You don't have discretion. You can't say it's imperative. I just say you don't have discretion. You're coming on
and just
anytime the Constitution say you don't have an NBA. Anymore. 48 hours near 48 hours absolute. And it's almost obi kukumu 7 days. What breach Article 14.3? What breach the fundamental human rights?
Na me ba cho me ba o. Wa man bail. If I can't meet bail condition, e dey na say EOCO 4 year other than
EOCO Sanko court. Here I come read this paragraph or no. See, you shall produce the person before court.
Yeah,
you know that kind of says me man bail condition Untumi meet here by 48 hours not to intimidate the neighbor court. That court a man is spending the custody with us while he is preparing to meet the bill. Now, man now in your custody in breach of a constitutional provision, saying so Untumi meet bail condition. You are coming it's dangerous and they say, and I mean no can say EOCO for waiting about the family. I'm family ana 48 hours next one. I'm mama me a bail condition of 2 million Ghana cedis. Make a find a way. It's not 10 years na me 2 million Ghana cedis and I made them.
Mami twa so. Say bia ye de me akọ. Me twa 12 hours. Not even 24 hours. Ba ho no ya ma me bail. Na ye ma me bail na be 3 days later me ntimi fulfill bail conditions na. Eno no so den na ho ma me.
Yes EOCO for no anase oma chi no de court. No mo consider court say. Omo de oma meet 48 no. Na emom na Wontumi meet bail conditions no enti court mo ho kwan no mo sound and keep you in your keep you in your custody. That issue of custody no is imperative. It is 48 hours. The officer will take 48 hours now, no matter what, it should be by a court order. It is not your discretion because the Constitution says that it is it is imperative. It removes every discretion. That is what the president you're at here for Ghana for doing in Abba say. Near Dina EOCO 4 year no. In
the wake of this, you know, it me at the EOCO 4 court.
Yes, in fact, you have me na me Wontumi lawyer. Me were 2 actions. Make me call the human rights court. No file process via friend habeas corpus.
Produce the body.
Produce the body. Produce Wontumi because you are keeping him illegally against a constitutional provision. Me file suit against them for unlawful detention because they have exceeded their mandate to detain or keep Wontumi in their custody, which is a constitutional provision of 48 hours. Into our issue bail condition, you see, it is very self-serving. You can't say no more, and very self-serving. Our issue bail condition, also keeping it. You are not a court. Wontumi has been in custody for over 48 hours. And
it's not just the 48 hours na so woni adwene bia se opesa odini court ekokache court ni say o meet bail condition e dey 48 hours na aso na enticha afekura na say o meet bail condition you still keep him there
bisa say me mama enye dangerous precedent near set and the politics into obi anka bi and a politician or be a businessman the back am na make esesu dia say the provision in Article 14.3, it is imperative. It gives nobody a discretion. Into wow komobi bill. Now san keeping us. You are serving your own purpose in disregard of a constitutional provision. Into your name Wontumi do them and your unlawful detention. And your illegal, it is an affront to a constitutional provision. Because and you Wontumi na bail condition. No. Into Wontumi bail condition of 15 million now Wontumi meeting. Because say you are against the 48-hour rule. And say court. Now what church court mu say me dey me man bill to me enti say court ebe ma okwan a o ma bia na wo twenka ho ebetu ho no now afraid they were meeting the bill. And no, he being in your custody is as a result of court order. You would have satisfied the provision in 14.3. How can cancel with phone because you shall produce the person before court within 48 hours. It is absolute. Constitutional can say if you can or you may. The Constitution didn't give you any discretion in that matter. It is a no keep you be more than 48 hours. The omitted bill is highly unconstitutional. It's not to speak up not because it's a political issue, but because it's a dangerous legal precedent.
It's not just as they seem EOCO seems to be arrogating powers onto themselves.
Of course, onto themselves. Because okay. Here I come.
Maminti 14.3 no enche Ghana Constitution no Article 14.3. A person who is arrested, restricted, or detained, A, for the purpose of bringing him before a court in execution of an order.
Under B.
Court. Nature say obi aya che no. Na yede na hyem ana yaje ne fa ahudi afiri ne nsam. Na botaye no ne say yede ne beba court. Na court order bi a wa hye ana
no eno ye me da say no ye no ko
okay. Or upon reasonable suspicion of having committed or being about to commit a crime offense under the laws of Ghana.
Thank you.
Who is not released?
Who is not released? That is
shall,
the word. Who is not released?
Shall be brought before a court within 48 hours.
Within 48 hours. There are coming church tree. Being a one church tree.
Ah, being was say, will be a yakin again for who to every in some and now can be so. Said be a ya were dream be say, what did bonnet? And now say on Kwan ya soso bi ekodi bone etia wa man ne mbra no ye nyai no esese 48 hours ebundowire aduana nwotwe no mu no ye de ba court after 48 hours ye de ba court na ye de ba gina mbra nim
me that come we and them clean
clean
we as clear as crystal clean into say 48 hours nesu na say that command bill gangantuan bill bi na wentimi amitia eyeboapa ye and you still want to keep the person in your custody but said that they are found using the bill condition but Article 14.3 and Mausa it doesn't give you that favor, it doesn't give you that discretion. It's in your lawyers Ghana for ayedin ebiane e Wontumi by ne ebetimi aye me kwame redu aminokase ebetimi aye ohinenana ebetimi aye obi bia enti the police they are showing and crash this precedent the police for baba ya ni say omo abecho omo chu ya wonnam ho 48 hours ne so ani ama bill condition kesie bi yes Wontumi meeting 7 years now with them ne papa mu
na ai ye kwa ye kan wo betimi I invoke the jurisdiction of a court at 14 5 no
yes
was it a person who is unlawfully arrested, restricted or detained by any other person shall be entitled to compensation from that other person
for compensation because Wontumi has been unlawfully detained after the 48 hours. The excuse that he is unable to meet a bail condition is illegal, it's unconstitutional. Nobody has that discretion
except the court.
And your home can say you could focus on money bill, bail conditional. But money bail condition now on to mean this no. Abro 48 hours no. And manager for Nebra court. Now back court to say, me the money bail nanso on to mean niti enti fa na watching me no ka ho fa na watching back and no na be court no when meeting the constitutional imperative of shall be produced before a court.
Enti other than the lawyers no so no
committee into them.
Other than the lawyers no so move motion of habeas corpus application.
You know constitutional interpretation no obiane senior ofano but that coming when you lawyer on church me a kind tree enye senior tiane say
sanity
it cannot be see the 48 hours no Supreme Court mpo share aka say Saturday ni Sunday kan first no yeah you free cross me say me free atim kusi and so who you be here na ye chap ye ka ye chakoti ama ye chakoti ma ye be chu be ifiada be nyimre be 6 the two be number 6 as you investigator no waponko fie oti krofu for so beba Monday anopa It's not a chink of fear. And when the Supreme Court can say even 48 hours, it includes weekends and holidays. Until now, the 48 hours, as presented in Article 14, it is absolute. It has no discretion. 48 this one assume and your bill now the mobi and you think Ghana for young never the move. Kofa a dying you fear me at a kwami. You can't young kofa block a dime running and yebia and you better mafia.
Nameka Kwase, Kope and Wa Utimi and Etumika 72 miles per hour. Slow, Ebra. And what Ben to be to American?
And nothing American say it's a dangerous precedent. If you all condone it as a nation, because we have accepted and agreed, say the Chrome Ghana had a rule of law near the better. You can't rule of law. We are always on the side of the law. We are always on the side of what the law says, not what the color of somebody's shirt is, not where he comes from. And yet, when we try to meet in our because Emran say, Emrani dia Igbenia, Edia Chimney, Edia Santini, Etio Bibia, Mama Yang Ghana for your tea a panel, and Untin Yachatu. And then Wontumi Yenye. What EOCO is doing is unconstitutional and it's illegal, and we need to speak up as lawyers. You don't need a doctorate degree in constitutional law to know that Article 48 is absolute. And it has no discretion, and bail condition cannot be used to frustrate the provision of Article 14.3. It is as clear as daylight. Intermediate Hami, Rakame Hami, and you will feed the case so. Because what checks him, because what Ghana for Jembra to say, near Yoko ye, and young commodity, because the better media will be Pia. The court to know on far inquiry, what demo more than 48 hours. Tanya Penno, or my teacher in
Mate, law. Miss Mekoswa Bodewuru, Wadaruma. That's it. Miss Meda say, Lawyer Bernard Owiredu, a private legal practitioner, and a national on okay 101.7.
OKFM 101.7.